If your loved one's been arrested, they're going to go through the complete arrest process before the case process begins. And so let's talk about what the arrest looks like. Once you're taken into custody, law enforcement will complete the arresting and booking process before anything related to your case begins. They'll either take you to their police station, to a holding cell if the agency is large enough, or most likely the majority of the time they'll take you to the county jail for where you were arrested. Once you get to the jail, you'll be booked in, fingerprinted, photographs taken, your property all booked, and then you'll be placed in a hold-in cell. Hopefully you'll be given access to a phone call shortly after you're taken into custody, where you can either contact your family or a bail bondsman office to help get you out. Once you are done with the booking process, the Sheriff's Department will set a bond amount for you before you have the opportunity to see a judge. That is the amount that you or a loved one can contact a bondsman or do a cash bond through the court clerk's office to get you out of custody while your case is pending. That is the end of the arrest process for you. You'll remain in county jail with a bond amount determined by the Sheriff's Department that's holding you based on the alleged charges presented by the officer that arrested you. And then the court process starts. That law enforcement officer is obligated to get those charges to the prosecution office that's over the county where you're arrested. That prosecution office will look at the reports and make an evaluation for whether or not they think any charges are appropriate. As a former prosecutor, I can tell you that receiving these packets of information is a daily occurrence in a prosecuting office. So either being hand-delivered reports by a law enforcement officer or through a submission process by that agency, prosecutors will take time throughout their day or their week to look at the reports, look at the videos available, potentially talk to the officer, and in the most serious cases, likely meet with detectives to evaluate what, if anything else, the prosecutor wants done to either plus up the investigation or what they need to go back out into the community and do before a decision is made. But once the prosecutor has a clear picture of what they think this case is, then they will make a filing decision. Something important to keep in mind is that the burden of proof at the criminal case in front of a judge or jury is beyond a reasonable doubt, the highest burden in our system in the United States. But for a prosecutor to make a filing decision, the burden is the same thing under Oklahoma law as it is for a cop to arrest you on the street, probable cause. So if a prosecutor thinks that there's probable cause or a limited amount of evidence that you committed a crime or multiple crimes, then they can file charges immediately and work on strengthening their case later. Shut up, lawyer up. It is never in your interest to speak to law enforcement if you believe you may be under some type of investigation. You will certainly have the opportunity to tell your side of the story, but that is always best done through your defense attorney. When you speak to law enforcement on your own, you are operating in the dark. You don't know what they're looking for, you don't know what they're investigating you for, and they control the environment, they control the narrative. We all have this innate desire to fix the situation or self-preservation. So law enforcement knows this and uses that as a tool or a tactic to try and entice you to help the situation. What you believe may result in you being released is likely the linchpin in making your case exceedingly difficult to fight or get a dismissal in. So when you talk to law enforcement, if you're under investigation, you're only adding fuel to the fire of you being arrested or being prosecuted with more serious offenses. If you think that you have something to say, shut up, lawyer up, period. Wait till you have the opportunity to talk to your attorney. Your defense attorney can convey your side of the story in a significantly more powerful way than you ever can by telling it to cops or detectives in an interrogation, or just being questioned on the side of the road. Because you and your attorney can work with their investigator, if they have one on staff, to build other evidence or witnesses or video or proof of what you're trying to say and present it to the audience that really matters, the prosecutor. Law enforcement on the side of the road is not a decision maker. Beyond, if they believe a crime was committed at that very low burden of probable cause, they're placing you under arrest. The party that makes a decision is the prosecutor, and that is who your defense attorney needs to advocate to, not the cops. Save yourself, save your future, shut up and lawyer up if you're being questioned by the cops. The purpose of bail in our country and in Oklahoma is to ensure the presence of someone in court and protect the community. So the bail schedule that exists in most county jails by offense and the bail set by a judge in a specific case is intended for those two purposes, to ensure you come back to court and protect the community. But it's a varying scale. So you and your attorney can absolutely advocate why your bail should be lower, why conditions should be less difficult on you. in order to show the court that you will appear for court and that you're not a continuing threat to people in the community. So bail is typically set the moment that you're placed in custody by the sheriff's department, but you and your attorney absolutely have the opportunity to go in front of a judge and seek a reduced bond or a conditional bond where you pay no money up front if you can present facts and evidence that shows that you're not a flight risk and you're not a threat to the community. Sometimes people get confused between their arraignment and their first court appearance. Arraignment is just a procedural step where you and your attorney go in front of a judge, you're advised of your charges, you enter a plea of not guilty, and you get your first actual court date. But at that first substantive court date, whether it's a disposition docket, a misdemeanor docket, or a preliminary hearing conference in a felony case, that is the first opportunity that you and the other side have the opportunity to start sizing each other up. You and your defense attorney can begin to present the problems with the government's case to the prosecutor, start advocating for why dismissal or reduced charges are as appropriate for your circumstances, and also build the mitigation, extenuation of the things going on in your life or in the case that are evidence of why you should get a less serious outcome than people typically do in your circumstance. That first court date is the opening chapter and a very important story of how you either fight your case or work towards the best possible resolution. If your loved one's been arrested in Oklahoma, I hope this video has helped you understand what the early phases of the process will be. I'm John Cannon with Cannon Associates, your fierce advocates, and if you have more questions about arrest or potential charges in Oklahoma, I encourage you to reach out today for a free case strategy session.